Perfect. Quick mic check. Everybody can hear me?
Yep.
Yes, we can hear you, Rich.
All right, welcome everyone to our monthly meetup. If you've been with us before, you know we do this every month. We gather some of the awesome latest trends, topics, and things you need to know as a marketer, and we create content for discussion. We usually do the content ourselves, but today's topic is very specific and it involves legal. So with that, we have a guest, an awesome guest with us, Megan Thomas, who I'll introduce her in a minute, who will be discussing everything you need to know about GDPR, CCPA, and some global outlook that you need to be on top of for the upcoming years. So let's just call this the 2022 updates. And the reason for doing this today is because everybody is worried about the GDPR compliance. How do I update my terms of services and privacy and cookie policy? How do I communicate transparency with my customers? So perhaps this is going to be a good resource for you to put you on the right path. Quick step back. This is a VBOUT community. So if you joined it from an invite, a friend, welcome. We've been 8 years in the making. The community is quite involved and quite decent, 20,000+ members. Plus we have our VBOUT customers who will also consume this content. But the 20K reach is a community of marketers, consultants, digital nomads. Everybody attends just for the main purpose of learning marketing and everything around marketing. If you want to use the community, you can join our meetup, or you can post things on the board. You can post things in the comment of the registrations. And even now in the chat, if you just joined us, I would love to hear from you, a little bit about you. Put your name, put your link to your LinkedIn profile, and any announcement you'd like to make. Okay, so you can use the chat utility to introduce yourself briefly, and we'll open up the floor for many of you to ask questions as we go. So overall, we're going to be doing about 15-minute general intros. Won't bore you with that. It might be about 5-6 minutes. We'll dive into the topic, which will take us 40 minutes plus, and then we'll do the general Q&As. I might have a little bit more time for Q&A, so I'm willing to stay until 6:15-ish. If Megan is okay with staying with us that long, that would be awesome. If not, I do totally understand, Megan. Your time is very precious. Quickly about VBOUT, guys. We sponsored this event, so I just want to put VBOUT here in the spotlight a little bit. We do this again every month. George and the team and myself, we organize the content, the flow of the information, the invites. And if you're wondering what VBOUT is, we are a marketing automation platform. So you can compare us to HubSpot, Marketo, and probably ActiveCampaign on the marketing side of things. Now, what sets us apart is that beside the fact that we are focused on the marketing stack, not the sales stack or CRM, we have a very simple interface for most people. We come at a great, affordable price, and we have premium support to back up our SaaS. We're not just a product that you use. We actually have a team of dedicated technicians who will be hand-holding you, making sure that you get the right resources so you can be an awesome marketer in your game. We also have a lot of predictive capabilities within the system we started to launch. We have subject line analysis. We have predictive sending that we launched recently, an amazing feature that can determine when your customers should be getting emails at what time. And we will also be launching a built-in AI for content generation soon. Very excited about this. It's still undergoing testing and finalizing kind of price structure through APIs, but it's something that you'll be able to create content for email, for social media by clicking one generate button from your account. So that's a really awesome feature we're working on. Now, in terms of the tools that we offer within the software, we cover the 3 phases of every lead, from the lead generation side of things. That means when we generate the leads through landing pages and forms. Okay. And I'm sorry, guys, some of you might not be muted. So if you don't mind just muting yourself to avoid the background noise. There we go. Thank you. So the first phase is just generating leads for landing pages, forms, and pop-ups. So we have the tools for you to create those through VBOUT. Once the lead gets channeled into the system, we track the leads, where they came from, attribution, page visits, and then we automate the sequences of events that happens afterwards. How many emails, SMS, web push, retargeting. So all that logic that takes place afterward can be managed through the system. We also have retention tools from email campaigns if you want to send out newsletters, social media, listening and publishing, retargeting, and a lot more. So the tool stack itself is 10 plus tools working together. And we integrate very well with third-party platforms, whether you use our native integrations that we've built, middleware integration like Zapier, Fably Connect, Integrately, and a few others. Or you can use some of our plugins or open APIs because we have an open API layer as well. A couple more slides on VBOUT just so you understand it fully. It's a very beautiful interface that we've built. We want you to be able to do things without the need for coding. And this is only one of our platforms, a flagship product, which is the drag and drop automation builder. And you can see right here, I'm building the logic of what happens from the moment somebody signs up. They get an email a couple of minutes later, then 2 days, they get another follow-up. And I can continue building this sequence to send SMS messages, to notify teams and do internal tasks and that type of stuff. So overall, this will allow you to build the sequence in an easy drag and drop interface. At the end of the day, what we empower you from the platform is to build your own first-party cookie data set and to own it. Which means we track email activity, web activity, social media activity, SMS engagement, purchases, attribution. So all that data, when you own as a marketer, you can easily create custom audiences. You can export them and target those people on Facebook or other ad channel of your choice. So obviously with the more granular data that you track in one place, the better handle you have on your data and the better targeting you can do. So if you're a good marketer, you definitely understand the value of this. And between the underkills of the world and the overkills, underkills are products that leave a lot to be desired if you're an advanced marketer, and the overkills that come with too many tools and things you might not use, very pricey. We are right there in the middle. So someone classified us in the past between the underkills and the overkills, and that's exactly the category that VBOUT is in. All right, enough about VBOUT here. I would love to take a step back and invite you to our community. If you're not part of our VBOUT meetup group, I would love you to join us. George is going to put in the chat a link to our Facebook group. This is where we talk about latest updates. We do monthly partner meetings where we discuss the latest features and releases. So please join our community. We promise you we're not going to be spamming you or anything like that. This is strictly for information sharing. And if you just joined us, welcome. We had a little technical glitch where everybody's name is George. This is because we shared the wrong link. So please right-click on your URL and rename yourself with the proper name. And if you don't know how to do this, you're just going to locate yourself. There are 3 dots right there. Click them and rename yourself to the right name. Cool. All right. Let's dive into the topic. Does anyone have questions so far? I know we're just starting up. We're doing general intros before we get right into the topic of today, which is the privacy updates for 2022. If you have any questions also during the presentation, you can drop them in the chat, whether you are on Facebook or whether you are right here on this live broadcast. We will make sure to note it and we will ask Megan on the go when time is appropriate or towards the end of the presentation. Okay, we are allocating a decent size of today's webinar for your questions as well. So if you want to save them towards the end, that's also efficient. All right. All right. Today's awesome guest is Megan. Hey, Megan.
Hello.
Can you hear me?
I can.
Thank you so much for joining us today. Quick intro. I actually met Megan while redoing our own privacy cookie policy for VBOUT. And as you can see, VBOUT is quite robust when it comes to how much data we track. So we needed a superstar to work with us, and Megan Megan was that superstar. So we worked on revamping our cookie policy, terms of services, and a few other areas to be fully compliant with today and all the recent updates. So she's the owner of a boutique firm she recently launched, focused on compliance and specialized transactions, located right here in Atlanta, United States. So if you are in the United States, I think you can certainly work with Megan. And Megan, if I am in Europe, can I work with you still?
Yes, I have a healthy amount of international clients.
All right, awesome. Here we go. So I'm putting Megan's information here, okay, because obviously she deserves a promotion. So you can contact Megan. This is her email. If you have any questions, you want your terms of services, privacy policy, any of this looked at, which I think deserves kind of protection. You want to protect yourself. You don't want to be out there targeting clients all globally, internationally, and not have those privacy buttoned up. Okay, so I highly recommend you take Megan's information. So if you have any questions, you want to work with her, the information are right there. Okay, and I've worked with many attorneys. I think one thing that I vouch for Megan is that she's very fast on responses, and she is very efficient. Not a big firm per se, and just like us, we're still a small company. Megan is a small firm, so that means that you have someone who's really passionate and they're gonna give you their attention. That's really important, to work with someone who will give you some attention. So without further ado, I want to present Megan. And if you are able to share your screen, Megan, you can take it from this particular slide. I'm gonna go ahead and exit real quick. Let me know if you can share it.
I apologize, I'm having
Don't worry.
a bit of an issue. Give me 1 second.
No worries. And if for some reason the slide is giving you trouble, I can drive the slides. I'll just follow your information flow. Okay.
Well, in essence of saving time here, because I want to reserve enough time for everyone to ask questions at the end. Rich, if you don't mind driving.
Yeah,
and as soon as I have an opportunity to break and try to re-download, then I'll do it from there. But if you don't mind driving from the slide you just left off on, that would be great.
Yep, not at all.
Sorry about that, everyone. So as Rich mentioned, yes, I have a small boutique practice here in the United States that's really focused on handling specialized technology transactions for, I would say, small businesses, businesses with less than about 100 attorneys. Employees, and that don't have an in-house attorney and don't have someone really driving an initiative to ensure that these businesses are in compliance with a growing area of concern in the market, which is privacy and privacy compliance. Rich, do you mind progressing to the next slide, please?
Sure.
And so privacy and privacy compliance is one of the biggest issues of concern in the legal space, and a bigger issue of concern for small businesses that are working in the digital age or in the digital market. And that's become increasingly relevant for over the last 2 years, because more businesses are focused on delivering services over the internet, not in person, and digitally, just due to limitations of the pandemic. And because it's now more convenient, the world is a lot more smaller. And so businesses are relying more frequently on communication online and digitally. And that means there's a lot more information sharing than ever before. So today we're just going to take a sort of a deep dive into what privacy is, what privacy means to businesses that are sharing information digitally, and more importantly, what are the regulatory laws and restrictions that businesses need to be aware of. So my intention with this presentation, which I give a couple of times per year, is to make sure that, the businesses and the individuals that are listening go away with at least knowing what privacy laws are relevant to them in their businesses, businesses what they need to do to comply, and what they need to do to prepare themselves in the future for this growing and developing area of law and regulation. Rich, do you mind progressing to the next slide? Okay, so one of the first things that I think would be very beneficial to do at the very beginning of this presentation is to talk about some of the relevant terminology. And there's a couple of different words, Rich. So if you can, just go ahead and add them all to the screen. Okay, great. So terminology in the privacy space is kind of different than terminology anywhere else because some of the privacy laws use a few key terms that I want to make sure that everyone understands. So the first term is personal data. And I think that's one of the easier terms to, sort of grasp. So personal data is any information that can pretty much be linked to an individual. Personal data usually means, like name, date of birth, but it can even be an IP address. It could even be, information that's collected about a person's whereabouts online, sort of information that's gathered through cookies or through like a cookie tracker. Another word that you need to be familiar with is data subjects. So data subjects are the individuals for who personal data is collected for. Data subjects are most readily going to be an individual, a person, and not a company. So just for the purposes of this discussion today, when we're talking about data subjects, think about a person, think about the person that's accessing a website, think about the person that you're collecting information about. It's not necessarily a company or a business. Data subjects are most likely going to be individuals. Now, another word that you're going to hear a lot when it comes to privacy law and privacy policies, and for this discussion, is the word controller. So a controller is the person or the business that processes data, that determines how data is processed for the data subjects. Again, that's a little bit of a legal nuance there. Controller is probably not so familiar to individuals, but a controller is the person that's going to be processing the data. The controller is also sometimes known as the data processor. They can be different individuals, but they can most likely they're going to be the same individuals if you're dealing with a small company. Bigger companies have a data processor, which is someone that actually processes the data, maybe like a marketer or something like that, that's separate than the controller, which is the business. So again, the controller is the business or the entity that determines how the data is going to be processed. And the processor is the business entity or marketer that actually does the processing on behalf of the controller. They can be the same person. All right, Rich, do you mind progressing to the next slide? And by the way, when we're getting started with this presentation, if you have any questions, go ahead and drop them in the chat. I have the chat up. I'll try to take a look regularly to see if there's any burning questions anybody has that's relevant to the slide, but we are going to reserve a healthy amount of time at the end to answer specific questions that the community has.
Thank you, Megan. And just for those who just joined, if for some reason your name is George, that's because we had a technical glitch. We shared the wrong link. So please right click on your name and rename yourself to whoever you are today, or you want to anonymize, and just so we know who's joining. And you can put a little introduction about yourself in the chat, some contact information or any announcement. So thank you, and back to you.
Sure. And I don't mind speaking to a room full of Georges. This will go down as something I remember. Okay, and Rich, there's also a few more points on this slide. So, okay. All right, so here are the basics of privacy law. This is sort of what you need to know as a business, or as an individual that's working in the privacy spectrum. So if you're a company that has a website or has an app or something like that, then privacy law is probably going to apply to you in these specific ways. If you are a marketer that has customers that are companies that have websites or apps, and you're, sharing data, with them or for them, or gathering data for them, then here are the basics that you're going to need to know that will apply to what you're doing. So privacy laws are the laws or the regulations that govern the use of customer or consumer data. So it just governs what we're doing with the data, because as you know, people are growing very, very, very concerned about what information is being collected about them, what information is being shared, and what companies are doing with that information. I actually think that people are more concerned about what that information says about them. And they feel that, their privacy has been exposed somehow. If they find out that Facebook, was able to tell where they're shopping based off of responses to a questionnaire or something like that. And so I think that privacy laws are growing really out of consumer-driven concerns, not government-driven concerns, but governments are starting to respond to consumer-driven concerns. And so they're coming up with all of these different laws. So consumer data is something that is globally undefined. So consumer data, the information that can be collected about a consumer, there's not really a definition of what that is and what that means across the globe. In different jurisdictions, you'll have different definitions of consumer data, but just know for the purposes of businesses collecting information or having a website or an application, that consumer data is anything that can be linked back to an individual. So if I visit your website and you collect my IP address, then that's consumer data. If I visit your website and you collect my email address, then that's consumer data. If I visit your website and you're able to tell where I live or what my shopping behavior is, that's still technically considered consumer data for the purposes of privacy law. Privacy laws generally only apply to information that is tracked virtually or online, but just so you know, privacy law also applies if you're tracking information, say, in your brick and mortar store or something of that nature. So it doesn't just apply to companies that have applications and companies that have websites. If you have a brick and mortar store and you don't have a website, which I don't really think, I think that's a unicorn in today's day and age. But if you have a brick and mortar store, then privacy laws still apply to you. There is no requirement under privacy law for you to have a website. If you're collecting consumer data, if you're gaining information about consumers in the market, then you have to be responsible with their data. And then lastly, privacy laws are most readily implicated when information about a consumer is not volunteered. So if you have a website and you're tracking information or collecting information about the visitors of that site or the visitors of your application, and that information isn't transparent to them, then that's when privacy laws really start to become implicated. All right, we can go to the next slide. Okay, so just to sort of piggyback on what I was saying, businesses are not exempted due to their size or because they don't have a virtual presence. Privacy laws are very, very new. I want to say probably the earliest privacy law is the GDPR, which came out in 2018. And we'll get into that in a little bit, but that's relatively new when you consider it being a law that has a lot of implications. And so sort of, the European legislator was very broad with their mandate. So all businesses, regardless of their size, whether you have 2 employees or 200 employees, are still subject to privacy laws. And that applies across the board. And whether or not you have a website or an application, it still applies to you. They're generally created to prevent certain abuses and data practices. So that's the end goal. So I don't want anybody to get sort of up in a roar about some of the mandates and requirements here. These are the tips and tricks that I'm going to provide are all things that you could do, without a lot of money, with a brief consultation with an attorney, or sometimes on your own without having to even consult with an attorney. There's many changes that you could make to your own policies that could get you in compliance with some of these laws, but don't get up in a roar about it, because the point of these laws is to prevent abuse across the board. And so if you're not perfectly, implicating a privacy compliance practice by the end of this presentation or by the end of the week or whatever your goal is, don't stress. The point is to get to thinking about being responsible with data. There's not really a data tracking police that's out there that's going to make sure that all of these things are enforced. However, if a consumer finds out that there's been an abuse of their rights, then they may file a report, and that's when privacy laws can be implicated. We can go on to the next slide because I'll cover some of this when in the coming slides. So there are lots of privacy laws that are starting to take shape and take form. The most notable one, I think, across the board is going to be the GDPR, which is the law that was enacted in Europe and also in the UK. So that's probably the most notable law. And that sort of started this whole domino effect of other jurisdictions, adopting their own privacy laws. The good thing to note is that many of the other laws that have been adopted in other territories are not bare bone copies of the GDPR, but they're pretty close. They use the GDPR as a model. So I would say that the GDPR is probably the most restrictive law when it comes to privacy laws. And so if you're in compliance with the GDPR, you're likely going to fall into compliance with many of these other laws. So we also have a similar law to the GDPR here in the United States, and it's called the CCPA, and it applies to citizens that are in the state of California. Again, it's a model of the GDPR. Canada is undergoing, let's just say there's a push in legislation for them to adopt a GDPR-like law. It didn't pass in October, I think it was, of last year, but it's on the table again for this year. And I believe that Canada is also going to have a GDPR-type privacy law enacted before the end of the year. And then we have lots of other jurisdictions that have bits and pieces of parts of the GDPR implemented into their privacy laws, but they don't have a law that is as broad. So this slide just really highlights that we have the European Union, which the UK was formerly part of the European Union and also took with it its own GDPR type law. And we have the United States. And then I want to say, I think Canada is going to be the next jurisdiction with a huge GDPR type law. So just know that if you are marketing or collecting information from consumers, or you have clients or customers in any of those regions, the European Union, the UK, the United States, namely the state of California, and probably by the end of this year, Canada, then these privacy laws are going to be very relevant to how you conduct your business. Okay, we can go to the next slide. All right, so I think one of the most important things to know is, well, what happens if you don't do these things? Like, what happens if you don't get in compliance with the GDPR or the CCPA or any of the other privacy laws out there? Because, honestly, some businesses have diverted from implementing certain compliance programs until a certain date because it could be too costly or burdensome or confusing at a certain time. And so I think it's important to know, what the risks are to not implementing a privacy compliance program. So number one, I definitely want to mention that under the GDPR, CCPA, and any other privacy law, there are financial penalties for businesses that don't comply. I'll go ahead and say that the most drastic financial penalties are reserved for the most egregious of violations. So let's just say that you made a mistake in your privacy policy and you misrepresented the information that you were collecting. However, you weren't abusing any data rights or using that information in an abusive manner. My guess is that you probably wouldn't face any staunch financial penalties. However, it might not be worth taking the risk, especially if it can be, especially if you can get into compliance without spending a lot of money and, just by attending a lecture such as this, which informs you of what you need to do. So just know there are financial penalties out there. I believe the most egregious penalties are going to be reserved for businesses that are really abusing these policies. I don't really know about, none of my clients have ever been fined for a GDPR or CCPA violation. And I would just say that I don't know many other practitioners that have clients that are fined for these violations. All the violation fines that I've been aware of have been with larger organizations that have a huge system of extrapolating data and some really sort of like covert mannerisms, and they weren't really being transparent about how they were commercializing that data, and they were making millions of dollars off of this information. And so those are the companies that I know about that have huge fines and penalties. But it doesn't make sense to take a risk if you don't have to. So another, I would say, probably more probably a likely penalty for businesses that are smaller, even if you don't get a large fine from some of these regulatory bodies, if a consumer, asks, do you have a privacy policy that discloses which information you collect about me, and you say no, then that becomes something that doesn't look good on the business, especially if that consumer knows that you're required to. You can lose sales, you could lose business, you could lose, if that line of business could do great things for your organization, or if that line of business could lead to other business, then that could be a big penalty. I do have clients that, you know, get asked regularly about their privacy compliance policies. And so if you're a client in that space, then that could turn you away from working with a certain business because you don't know if you would be in compliance by working with them because they're not in compliance. So I think that that's a more likely concern for smaller businesses. Also, there is a lot of talk about globalization in today's space when it comes to companies that are in the technical space. So globalization in and of itself just means that businesses are going to be communicating more readily in a digital medium and online. So just know that privacy laws are here to stay. And I believe that they are going to grow as the world gets smaller and as companies rely more and more on the internet for communication. So keep that in mind. Small companies have a global reach, and consumers are able to work with businesses on all sides of the world. Sometimes you're not going to be able to segment your market and say, this customer is in the European Union, and so I need to have a privacy policy that applies to them, and this customer is not in the European Union, so I don't have to have a privacy policy. Sometimes you're not sure where your customers are going to be at any given time. So I think globalization is one of the risks of not having a privacy policy. From my perspective, 5 years from now, most companies are going to definitely, you know, be working with people all over the world. Also, public awareness is a big risk. You know, public awareness is just one of those things that if there is a data breach, or if your company is on the wrong side of a privacy violation, it's much more apparent, you know, to businesses and consumers now that, you know, you've been on the wrong side of that violation. Stuff will be broadcasted online, you know, instantaneously. And so I think that's a big risk. And so I think overall, the biggest risk might not be financial risk, but the other risk, you know, sort of losing sales, losing businesses, or having a bad reputation online could also lead to financial implications. All right, Richard, can you progress to the next slide?
Sure. And if you have joined us now, guys, please make sure you rename yourself because we had the wrong registration link. So your name might be George. Just right click, rename to the proper name. And if you have any questions for Megan, you can drop them in the chat or in the Q&A section. We'll make sure to get to them at the end. I'm pretty sure a lot of you will have, they came here for a couple of questions that they would like answered. So you use the Q&A or the chat section on Facebook because we're broadcasting this to our group, or here, and we'll definitely get to it.
Yes, and I do see a question here. GDPR applies only when we send information to a customer, right? So that's actually, it's sort of the inverse. The GDPR applies when a consumer accesses, you know, your website or your application, and you collect information about that consumer. So it, generally speaking, it applies always, you know, it always applies. But if you collect information about a consumer, then you have responsibilities under the GDPR. So I think you can think about it that way. If you gather or collect information about a consumer, you are required to disclose the information that is collected. So even if you don't send anything to the consumer, if the consumer just accesses your site, you gather information about that consumer and you use it for some purpose, whether or not you're using it to sell that information, whether or not you're commercializing that information. But if you're just gathering that information, you do have to disclose the fact that you collected that information, whether or not you market it at all. You could just be using that information to tell you information about, you know, website traffic or something like that, and you are required to disclose it under GDPR. Okay, so let me move back to the slides, but if you have any other questions, make sure you drop them in the chat. I'll get to them. Yes, I'll try to get to them as they come up. So here are the core principles of privacy law regulation: lawfulness, fairness, and transparency. So basically, privacy law regulation wants to just make sure that there is a lawful way in collecting information, which just means that you're not buying data on the black market. I think most businesses aren't doing that, but there is a black market for data because data breaches and data pirating and, you know, I heard a term today, data hijacking, or yeah, data hijacking is something that's, becoming a growing area of Black market crime or something of that nature, where information is being shared, for nefarious purposes and whatnot. So the data collection method has to be lawful. You have to buy it from, if you're buying data, it has to be from a legal body or a legal company. It has to be collected in a fair way. And transparency is probably the biggest mandate of GDPR and CCPA law, because you are required to be transparent in the information that's being collected. So gone are the days where a company can collect information about customers and not disclose the information that's being collected. So we have to disclose the purpose of the collection of data. We have to minimize data sharing that's not in accordance with the information we're disclosing. So if you're disclosing data for a specific reason and you're stating on your website's policy that you're disclosing it for this reason, then you probably aren't going to be able to disclose it to any other person or any other company for any other reason. So it's really important that you minimize data sharing outside of the ways that you're disclosing that you are actually sharing it. So another purpose of GDPR and CCPA and privacy law regulation is making sure that we're maintaining the integrity of the data that's being collected. This really applies for companies that are collecting financial information or credit information about a consumer. So if you're, collecting information about a consumer and it says that they have a bad or, negative credit rating, and that information is not accurate, then you will be required to update that information under privacy law mandates. And also, privacy law mandates limit how long data is going to be stored. The longer a company stores data, the more risk there is to that company of the data being hijacked, or the data, ransom was the word I was looking for before. There's data hijacking and ransom police now on a federal basis. So the longer you store information, the more that you're risking data being hijacked or held for ransom. And that's a really big area of crime that's I guess it's occurring very frequently across the globe. And that's why privacy laws want to limit the amount of data that's being stored, because the longer you store it, the higher the risk is that something could happen to it. And then we also want to make sure that data is kept confidential. So we want to make sure that we're storing it with, the most secured or legal or regulatory regulations and mandates, because if it's being stored by, not encrypted or not in a secured database or something of that nature, again, you're risking data breaches, data being hijacked, or data being held for ransom purposes. And then the other purpose of privacy regulation is to make sure that businesses that are collecting information are truly being held accountable for the information that they're collecting and the methods that they're storing data and the information they're giving to the public about how they store data. We can go on to the next slide. And so with all of that being said, I think that was the nuts and bolts of data regulation and what you're going to be looking at in any sort of GDPR, CCPA mandatory policy. We'll get a little bit more into the particular requirements under the GDPR and the CCPA, but that was sort of the overview, because again, most countries that are implementing data laws are using those principles when they're making their specific types of laws. So we will go into the GDPR and CCPA a little bit deeper in the next few slides, but I just wanted you to know what the overarching themes of data laws are across the board. So that's what you're going to see in most privacy policies nowadays. So the privacy policy is basically let's just say if the privacy laws are the regulations, are the sort of orders that are flowing down from the courts about how you store and manage data. The privacy policy is the document where a company tells the public what data they are collecting, how they're collecting it, and what the public can do to get their data removed from the company's database. So the privacy policy is a customer facing document. It's going to usually be a link or a policy that's located on a website or that's located on an application that says, this is the information we're collecting. This is how you can tell us that you don't want us to collect that information anymore. And if you want us to delete your information out of our database, just write us and tell us and we'll take it out. And that's what's required under every major data regime that's out there. So yes, the privacy policy addresses the mandates of various privacy regulations. It specifies a company's data practices, and it's a required document for businesses that collect data. And most businesses that have websites or have applications collect some sort of data, even if it's just an IP address for moments. So that's what the privacy policy does. It's something that's required for most businesses that have a website, that have an application, because it's really hard to operate in the digital space without coming into contact with any kind of consumer data. It's just almost virtually an impossibility in today's market.
I just want to add to that because I know some questions are still coming in, so I'll reserve some. And thank you, John, for answering a few of these. When it comes to privacy policy, I know every single person attending today's meeting or webinar probably have one or is in the process of revamping it. So I would like to know in the chat, who of you actually have theirs buttoned up, who think they need some assistance with it, and they're kind of lost in that area. What should they add and how they should word it? I would love to hear from you in the chat. Just drop in, what are you struggling in your privacy policy? But please, before you do that, can you rename yourself, because we have everybody's name as George Fala, and that was a technical glitch. Right click on your name and just put in the proper nickname for yourself. Thank you so much. I will move on to the next slide.
Yes. Okay, so consumers look to privacy policy for what I call the double Ds: disclosure and delete requirements. I would say that I can't give a percentage, but if I'm going to estimate what amount of consumers actually look at privacy policies, I think it's less than 1%. You're going to have that one consumer that maybe is in, data regulation, they're in technology, there are companies, in their IP department. And so they really know about these issues and they'll be looking at privacy policies. 99 times out of 100, you're probably not going to get an inquiry for a consumer who wants to take a look at your privacy policy. But when they do, they want to know what information the company is collecting about them. So that's the disclosure requirement. Companies have to disclose what information is being collected about them. And I do want to mention that, under GDPR, CCPA, and most privacy laws, companies have a broad requirement to disclose pretty much all information that's being collected. Now, you don't have to get down into a very granular level and list every single data point. You can categorize or group the data into different sets. So you can say, if you're going to if you're collecting name, date of birth, and things of that nature, be transparent about that. But then if you're collecting subsets of that data, then you can say, if you're collecting a consumer's, web traffic history, you can say, I'm collecting behavioral data about shopping behavior. You don't have to say, I collect that consumers go to this site, I collect if they went to this site. And you don't have to break down your algorithms for consumers. You can group it into subsets, but if you're collecting name, date of birth, and things of that nature, then I would say that you would be required to disclose specifically those data sets. Privacy policies, they're not contracts, but they should be viewed as binding agreements on the company. So because of that, I would say that you should be very, very, very careful about making sure that the ways that you're collecting data and the ways that you're grouping data and the data that you are collecting is transparent. Because if it's found out that you're misrepresenting the way that you're collecting data or the data that is being collected, then that could be found as a violation under law. So it's not a contract, but you could be found as violating a certain privacy law, and you could be subject to fine, penalties, or, like we talked about, the sort of social mores of being found in violation of privacy policy laws. Regulators can bring actions for violations of privacy policies. In the US, the Fair Trade Commission, which is not our government, so to speak, they're a branch of our government, they actually bring actions for unfair and deceptive advertising and unfair and deceptive marketing practices for misrepresentations of privacy policies. So it's important to be accurate as possible. We can go to the next slide. All right, so we're going to do a quick little scenario just to see if everyone is sort of following along. And I think everybody's going to get this if most of the businesses on this call have a privacy policy or are thinking of getting one. So we'll go through this one quickly, and you can answer in the chat if you'd like. So Paul is the owner of a small bakery in the UK named Village Bake Shop. Village Bake Shop has been a favorite sandwich and hot beverage cafe for the community for over 20 years. There's more on that slide, Rich. All right, so Village Bake Shop offers discount rewards for customers that drop their names and emails addresses into a glass jar at the register. Now, Village Bake Shop does not have a website. They don't have a mobile application or any other virtual presence except for being indexed on Google. Paul stores Village Bake Shop's information on a hard drive in his Mac. So the question that's going to be asked here is, does Paul need a privacy policy, and is he subject to privacy laws? And we can go to the next slide. All right, so I'm seeing yeses here. That's true. Though Paul does not have a website, though Paul does not have an application or a virtual presence, he tracks information. And so because the GDPR says that businesses that track or collect information about consumers are subject to privacy regulation, it applies, even if he doesn't even have a good way to disclose his privacy policy to consumers because he doesn't have a website. So I just want to point that out. You know, it does apply even if you don't have a website. You should still have a privacy policy if you're gathering information. All right, we can go to the next slide. That's right, he is storing personal information, Peter. Must Village Bake Shop have a privacy policy? The only reason I say privacy, probably not, is because there is no, if Paul does not have a website, if Paul does not have an application, then there's no way to disclose that information to consumers. I mean, Paul could have a paper privacy policy if people call in and write for it, but for practical reasons, I'm going to say I don't think that Paul would get fined for not having a privacy policy if he's just collecting information that's volunteered by consumers to get like discounts and things of that nature. So again, the privacy law applies. He has to be transparent. If someone asks for it, maybe Paul has to write something up real quick. All right, we can go to the next slide. All right, so what if Paul learns that Village Bake Shop's customer list, the name, home address, and email address could make Paul more money than selling baguettes, and he decides to monetize that policy? Will Village Bake Shop need a privacy policy then? At that point, I'm going to say, even if Paul does not have a website or an application, I think he needs to get an application or a website and put a privacy policy online, because if you're monetizing, data, at that point, I say it's very risky to not have some sort of virtual presence where you can disclose that information. All right, we can go to the next slide. All right, so let's get a little bit deeper into the EU and UK's mandates, because I think that that's going to be most applicable to most people that are operating in the digital space here, because they have the broadest regulations. So the EU and UK regulations under the GDPR pretty much became enforceable in May of 2018. It applies to the processing of personal data as a whole that is obtained by automated means. And it also applies when it's obtained by other than automated means, such in the example with Paul. Even if information is intended to just be part of a filing system. So if you have a company and you're just filing information about consumers or your customer base or whatnot, then yes, the privacy regulations do apply to you. There are exclusions under this system. So if you are able to make your data anonymous, if you do that and data is not tied back to an individual, then technically it's excluded from GDPR regulation, but that would have to be the whole data set. And I am not an IP person. I'm not an IP, or technology professional, but I would imagine it would be very hard to store meaningful data that's fully anonymized. I think it would be very difficult that at some point you'd have to link it back to a consumer. I don't know many businesses that have a full set of anonymous data. I know it can be done, but at that point, I think then you're just sort of like collecting data about the market. So if you're doing that, then you could be excluded. If a person is deceased, then that information is excluded. And we could get further into that line, but if you're collecting information about live subjects and the data is not anonymous, then you will be subject to the GDPR, which is the regulation in the European Union and in the United Kingdom. All right, we can go to the next slide. All right, I see a question here. In the UK, should we still register with the data protection registry? So that question is, it depends. So if this is John Drinkwater to everyone. So if you're located in the UK, if you have a brick and mortar, you are required to register with the data protection registry. Now, the reason being is because in the UK, which is different from other jurisdictions, they actually have an organization that is responsible for maintaining a list of all of the companies that are collecting data about data subjects. So if there's a breach, they know who to tie the information back to. So if you have a brick and mortar in the UK, absolutely, you are required to register. If you're a company that's operating outside of the UK, but you market to consumers in the UK, you're not required to register unless there's other specific requirements. So that we could get more into those specific requirements depending on a specific scenario. So your business may qualify even if you're not listed in the UK, but it would just depend on how your business is operating outside of the UK. And that's a great link. The ICO is the registry body that can give you those specific requirements as well. And that's a great link. I think I might have that link either at the end of these slides or in a manual that I have. Okay, so global considerations. Let's just talk about the territory for the EU and UK GDPR. So the GDPR in the EU and UK really applies if the organization is in the EEA or markets to consumers or data subjects in the EU or the UK, and it offers goods or services to them. Even if the organization is not located there, as I said, organizations that are mainly focused on collecting information about subjects and behavior that takes place in the EU or the UK are really subject to the GDPR. So you don't have to actually physically be located in the EU or the UK. You can still be responsible for complying with the GDPR and privacy regulation in those markets if you do any of the things on this slide. We can go to the next one. Okay, so we're going to go to another scenario. So PETA owns an exotic pet store in Madagascar called PETA's Pets. PETA's Pets ships rare birds all over the world and has a small share of exotic birds in Portugal. PETA's Pets hosts cookies on its website that provides PETA with valuable information from a customer's buying behavior to determine which add-ons PETA should offer its site's consumers. Is PETA's Pets subject to any privacy laws, and is PETA's Pets required to have a privacy policy? I think the answer there is going to be very clear. I think this is a very savvy group, and you're asking great questions. So the answer is going to be yes and yes. Is it subject to privacy laws? Yes. To GDPR, certainly, because it's marketing to consumers that are in the UK, even if it's located in Africa. And is it required to have a privacy policy? Absolutely, under the GDPR. If you meet any of those requirements, you're marketing to customers in the UK, you're shipping goods and services, you have to have a privacy policy. Okay, we can go on to the next. And I think we have a question in the chat. All right, here. So let me scroll up a little bit. Okay, so a question from Sergio on Facebook. I'm sorry.
I was gonna say I'm not missing any questions. I was gonna just reserve them to the end, just so you can. But if you want to go ahead and go with Sergio, you can.
Okay.
You can answer
All right,
that.
I'll do this one. I'll reserve the rest for the end. All right, so we have a question from Sergio on Facebook. What's the mandatory policies on a website privacy policy, terms of service, DPA for a business in the EU? What's the mandatory policies on a website privacy? So I think basically Sergio is asking what are mandatory? Does a business have to have a privacy policy, terms of service, a DPA, So the DPA, for those of you who may not be familiar, is a data processing agreement. So if you are a data processor or you're working with a data processor to process or store data, then you do need to have a data processing agreement. I mean, that's definitely just good practices. The GDPR doesn't require that information is transferred via a data processing agreement for every company that's not processing data. So you don't, if you're not working with a company to process your data, but you're sharing data with a company, but they're not processing it, you may not have to have a data processing agreement. I think that's a little bit specific to what's going on with the particular business and how that business operates. But at minimum, I would say that you would definitely need a privacy policy, likely a website terms of service, depending on what you're doing. You don't have to have a terms of service for, like, if you just have a dog groom and shop or something like that, you probably don't need a website terms of service. If you have a privacy policy, you'll probably be fine. And if you have a dog grooming business, then you definitely don't need a data processing agreement. And that applies whether or not you're located in the EU. So if you're processing data with a data processor, and if you're doing that, you'll know exactly what that means, then yes, get a data processing agreement. If you're sharing data with a marketer, you don't need a data processing agreement to do that. And you probably at minimum need to have a privacy policy if you have a website. And a website terms of service can be a little bit redundant if you have a privacy policy, just depending on your type of business. I'm not sure if I answered that question fully for Sergio, but feel free to
maybe I can play on the scenario. If you are doing business with VBOUT or you are storing your information on VBOUT, probably you need a data processing agreement with your end customer. Is that correct? If you're an agency, that is correct.
So if you're an agency, yes. If you're an agency, if you're VBOUT's customers and you're using VBOUT's product to market surveys or to
emails.
Yeah, emails and things of that nature. So I would not say that you need a data processing agreement. You may have to have permission from that customer to, go gather, collect certain types of data, but not a data processing agreement. So that would be a little bit different.
Got it. And we do have one on our website that we are fully open to share with you guys. If you want to extrapolate whatever information you want and repurpose it, by all means, you can do that. And I think, just for the terms of services, it's just the way that you're conducting business, how you're doing refunds, how you're processing memberships, how people can maybe use your website to what capacity. It does involve legal jargon, but I wouldn't think it's as sensitive as GDPR, considering the hype around GDPR. And every business has their own ways of, how they process credit cards on the 3rd of the month or the 1st or the 30th. It doesn't. So all of these are worth having terms of service. Definitely. Privacy policy is key for understanding how to share data, and DPA, which I think we just discussed. If you are an agency doing business with a company like VBOUT, it's worth seeing how data is being transferred.
Absolutely. And that's a great point, Rich. I may have answered that question related to the terms of service from, is it required under GDPR? Well, then the answer is no. Terms of service not required for GDPR, but it's a great business practice to have. So let's leave it at that. I'm thinking with my legal hat on, but yes, it's a great business practice to have a website terms of service. Okay, so I think we talked about having a lawful ground to collect data. I mean, lawful grounds are for performance of a contract, compliance with a legal obligation. Really, for the purposes of individuals that are going to be on this call, most likely the lawful reason or purpose to collecting data from consumers is going to be for performance of a contract. If a customer is coming to your website to use your services and you've agreed to provide them a certain service, for a certain price, but you collecting certain information from them in the process, whether or not it's required to fulfill that contract through completion, if you're just collecting information through the process, that's still sufficient under the purpose of performance of a contract. So you can have a specific requirement for a customer to give certain information to you in order to fulfill your contract, and then that's fine. But you can also collect information or extrapolate information from a consumer along the way, and that would still meet your lawful purpose under GDPR. So I would definitely say that. I mean, vital interest, public interest, and things of that nature, that's going to apply to, public bodies, government entities, health entities, and those sorts of things. Another one of these factors that is going to apply, or a lawful ground that's going to apply to individuals on this call, is likely consent. So when consumers come to your website and they consent to your cookie policy, or they consent to, by virtue of using your website, to share IP address information, then that's consent. You don't actually have to have a written contract or a written agreement from a person to say that I consent to you collecting information about me, storing my IP address information or whatnot. They can click a box and say that that's okay. Or some websites also use, the pop-up where it just says, hey, by virtue of accessing the site, you agree to our privacy policy, which can be found here, and to our cookie policy that can be found here. And if you don't like it, don't use our site. That's sufficient as well. All right, and we can go to the next slide. Okay, so just to piggyback on consent, consent does have to be freely given, which just means that, I'm not sure how consent could not be freely given or whatnot, but it does have to be freely given. It has to be very specific. So you have to be specific about what the consumer is consenting to. You have to inform them of the data that you're collecting from them. They have to be informed. So it has to be transparent and on a certain space in your website, usually when a consumer first accesses a website or an app, and it has to be unambiguous, so those things really go to the fairness and the lawfulness of the collection purposes. So silence and pre-ticked boxes or inactivity do not establish consent. So what that means is that if you don't have a pop-up box where someone has to say, if I still access this website, then I'm consenting by virtue of accessing the website, or if the box is already checked, then that does not establish consent. That's been established through some recent cases that have come up under violations of the GDPR. So just know that basically you have to have some way for consumers to know, and for it to be, in their face and informed when they access the site, to know that, hey, I am giving consent. They have to be able to say, okay, I don't consent, I don't want to continue, or they can click a box. So no pre-ticked boxes. Withdrawal of consent has to be as easy as giving it, which is the reason why, and I think, Rich, you're going to VBOUT site to show how the cookie policy comes up. Okay, or you're just checking? And so they have to be able to withdraw their consent very easily as well. Again, consent can be easily given. It has to be just as easily withdrawn. You can't require a consumer to have to write in to corporate headquarters, using snail mail with 2 stamps and whatnot. They have to be able to withdraw their consent online very easily by sending an email or clicking that same box that they clicked in order to access the website. And then for special data that's being collected, and that's really data that's going to relate to, certain health conditions and medical data, then you have to have a different type of consent. So if you're in the space where you're collecting health data, just know that you're probably going to have a different type of consent. Click consent probably is not going to be sufficient at that time. That if you're collecting that type of personal data, I would say you probably need a consultation with a privacy attorney or a privacy specialist in that space. And then if you have minors coming to your site, just know that minors can't give consent under GDPR or any other type of privacy law. Their parents are going to have to consent for them.
That's great. I just wanted to show, I guess the consent for what we're collecting and what we're not collecting, as you're talking more about the consent on this cookie. Everything needs to be ticked off by default unless it's chosen otherwise. Is this what you're referring to for those of?
Yes. Yes. So you see on VBOUT site, the cookie policy, pops up as soon as you get to the site. It's very transparent. You can't just have a link to the policy at the bottom of the page. You have to have some sort of ability for a person to give that consent as soon as they access the site or shortly after entering into the space. And as you see, Rich has the button where you could just reject all. You can select which type of information can be consented to, or to reject certain types of information. I would say that VBOUT's policy is a lot more detailed than many other businesses in that space. So kudos to VBOUT. I was very impressed when working with Rich, how they have their consent written up essentially. And also I would say that one of the things that's great about VBOUT site is that when you go and you access their cookie policy link, you also can access all of their, you could access the full cookie policy, and then they have links within the cookie policy to other relevant policies. So you can access everything with the click of a button, and it's very easy. And then their opt-out requirements are just as easy as well. So I would say that VBOUT is in full compliance with their requirements by having such an enhanced system. But VBOUT is definitely getting an A++. They've done more than necessary. But that's good.
Stop it.
Better be safe than sorry.
No, it's okay. But I do agree. You have to have disclosure what you're collecting and the data and all of that stuff. So if you are working with a cookie widget or using some sort of a platform, we're using Ayubenda, which is a decent platform for managing this. A little bit more complex, but if you get to learn it, it's good. And there are a few behaviors that you guys need to know. People can come to your site, they could see that cookie pop up, and they could close it. Now, you have to know what happens when they close it. If they close it, you probably need to, by default, turn off all tracking. So that's really important to know, because a lot of people have tracking turned on by default, and they start tracking things even if people close that consent pop-up. So the default behavior should be, in the EU at least, it should be off by default unless they say yes to it. Is this right, Megan?
Yep, absolutely.
Okay. In the US, however, it could be turned on by default, and they could have the option to turn it on and off. Is this still the case?
Yes, yes. And that's because in
Okay.
the US, even though the privacy laws here in the US are modeled after the GDPR, it's sort of like a mini GDPR. They're not as restrictive. It's a little bit harder of a pill for us to swallow here in the US. So that's absolutely right. And so, I mean, this is sort of, and you could go to the next slide, and, you know, we're going to skip through this scenario because I think that, you know, everybody is fully, you know, kind of getting the flow of what's required and who's subject to privacy laws. And we're running short on time here. And we can skip this one too. But in the US, I think that it's important to know that, you know, we're modeled after the GDPR. If you're in compliance with GDPR, which most businesses, the GDPR is the standard. If you're in compliance with GDPR, you're going to be in compliance with 99% of your requirements here in the US. You're just going to have a few different sentences to allow people in the US to know that this is how you opt out of, you know, privacy tracking or having information tracked. And here is where you can write in to get a copy of the information that's being tracked about you. So I hate this word. Pseudonymizing, I hope I said it right, pseudonymizing is key. So I think it's a really good thing for businesses to do if you can do it. If you can keep data from being linked to a specific data subject, if you could do that and just maybe have like a data key that tracks that information, but the majority of the information that you store is not linked to a particular data subject, then you've just wiped out so many of your risk here. You've wiped out your requirements to have to disclose information on certain individuals. If someone writes in and says, hey, what information are you tracking about me? The answer could be none. The answer could be none, you know, and if you're able to find a way to gain value and insights out of that data and then take someone's name off and take this person's personally identifiable information because you may just be interested in marketing behavior, then if you can do that, then I would say that you know, number one, it's encouraged under the GDPR, and then number two, you've lessened the burden on your business to have to even respond to requests if someone wants you to disclose what information you're collecting about them. So to me, if you're able to do that, I know not all businesses can. Some businesses actually need, you know, customer name. They actually need this person's last four of their social security number to make that data meaningful. But if you can do that, then I would say, you know, try to do that and try to work with a partner to have your data be pseudonymized because it will reduce the burden on the organization tremendously. And the GDPR doesn't apply to anonymous data. It just doesn't. So there you go. And neither does the CCPA and privacy laws that are developing around the globe, because you can't track who that information applies to. As long as you're not storing personal information, then you've lessened your burden. Okay. And so just really quickly on transfers outside of the UK or the European Union, this comes up a lot for for companies that are working with consumers and businesses in the European Union, but are located outside of the European Union. So this is where, having that DPA comes into place, that data processing agreement. Make sure that you have, the appropriate standard model contract clauses. The IPO definitely has a model contract that you could even just take their model contract clauses. You can work with a privacy attorney to get model contract clauses, but just make sure you have a contract that has the latest data protections in it, because it's good for you as a business. It's good for the information that you're sharing with the data processor, because everybody knows the standards of handling that data. And just know that you may need certain kinds of consents to process certain data. So if you're processing health data, just know that under the GDPR, you're going to need certain types of explicit consent, even if you're transferring that data outside of the European Union. The risk is that if you're transferring, data to Singapore or some other country that doesn't have as robust data protections, data could be lost, in a market, and there would be no way to protect an individual from having their information shared. Okay, we can go on to the next slide.
Sure.
Okay, so I'm going to summarize this, really quickly, because we spent so much time on the GDPR, which I think is really important, because that is the foundation for data and privacy laws across the globe. So in the US, we have the Federal Trade Commission Act, which prohibits unfair and deceptive practices. And so they do take the position that dissemination of personal information in a manner that's indicated differently than what's on a privacy policy is a deceptive trade practice. So that's one governing area of law. We have the California Consumer Privacy Act, which is the California version of the GDPR. It does apply to citizens in the state of California, but as you know, people port and they could be anywhere. So if you're marketing to consumers here in the US, you are still subject to the GDPR by virtue of having to comply with CCPA, which is a model of the GDPR. And then we have some other states that have, very lax data privacy mandates that apply mostly to companies that are big data processors. And so it's not going to apply to a vast majority of individuals in the community. But just know that if you are in the states of Virginia or marketing to consumers in the states of Virginia and Colorado, and you're a big data processor, then you could have some heightened data security requirements for your business. We can go to the next slide. Okay, and as I said, CCPA is modeled after the GDPR. It requires individuals that are operating online. So it's a little bit different in the GDPR because it applies to individuals that are marketing online, that have a website, that have an online service. So it's a little bit different from the GDPR in that way, because the GDPR applies to even brick and mortars that don't have an online presence or a virtual presence. And again, just like with the GDPR, if you collect certain categories of information and you share that information with a third party, or you collect information about these third parties, then you have to describe how individuals can get that information, get a copy of the information that you're collecting about them, so that they can ensure its accuracy. And then you have to also give them the opportunity to have that information deleted from your file. So it's the disclose and delete requirements. So disclosure and deletion is sort of the main mandates of the CCPA, and they just take those mandates from the GDPR itself. We can go to the next slide, Rich. All right, so I'm going to skip over this scenario for the essence of time, but basically what I wanted to do was to demonstrate that even if you're not located in the state of California, but you're dealing with customers in California, as if you have a virtual presence online, then yes, you are going to be subject to the CCPA. So if you're not dealing with any customers in the US, then you don't have to comply with CCPA. There's a small difference between the CCPA and the GDPR when it comes to disclosing to customers which information you're collecting about them and how to have that information deleted. You have to specifically say that these are their rights under the CCPA, and that this is what they have to do, and this is how they write it. And you have to use the buzzwords CCPA or California Privacy Protection Act. And if you don't market to customers in the US, you don't have to worry about it for right now. But even if you are, located in another jurisdiction, if you're marketing to a customer that's in California or in the US, then you are going to be subject to the CCPA. So as a review, The GDPR applies to your business if your business handles personal data and offers goods or services to individuals in the EU. The CCPA applies to your business if your business handles personal data, and it also has a digital presence, and you're getting that information from individuals that are in the state of California. So those are the big differences, but everything else is virtually the same. Everything else is virtually the same. And I'll go ahead and add that if Canada passes its Privacy Law Act, then the proposed legislation is just like that of the GDPR. Every jurisdiction seems to be taking the mandates of the GDPR, copying them because I guess they work to some fundamental extent, and implementing that into their own country's legislation. And so it will be the same thing, but you'll probably have a little bit of different terminology. So if you're GDPR compliant, the way the legislation in Canada is proposed right now, then you would be compliant with the Canadian privacy law by virtue of being GDPR compliant, but you may have to state something different in your privacy policy to say that if you're in Canada, here are your rights, as a Canadian citizen, and this is what we'll do for you special that's different from our customers in other states. All right, so I know that was a lot. And if this is what you do to get compliant, because I gave you a lot of information. I know that, this hopefully it's clear to you, but if it's still as clear as mud, what you need to do is just make sure that the decision makers in your organization, are at least aware of privacy laws and privacy regulations and what they mean. You can give them a copy of this slide deck. I think that that's probably a great starting point, and it may be all that you need for most businesses that are on this call. Ensure that if there are updates to how your company is doing business and how it's collecting information, and how it's storing and sharing information, then just make sure that those key individuals are still aware of it. And you can give them training if necessary. You can deliver them a copy of the slide deck if necessary. The best thing that your organization can do is, number one, record the type of information that's collected. Have it listed down so that if someone asks you about it, you can disclose that information to them, even if you don't have a privacy policy yet. But I'm telling you, the privacy policy is probably one of the easiest things that you'll do when it comes to privacy laws, just having a policy that lists all the information you're collecting. So to prepare for the privacy policy, just write down all the information that you store, write down what's done with it, and how you do that, and how often you do that, and then write what information you need to tell data subjects that's collected about them. So that is probably those are the three top things that you could do to prepare yourself to get privacy law and privacy regulation compliant, and to prepare yourself to have a privacy policy written for you, or to write one yourself if you want to give it the old college try. Those are the things that you could do. And it sounds daunting, but when you think about it, you're already doing it anyways. You're just documenting what you're doing, and you're just making sure that you're being transparent about what you're doing, and that the consumers you're collecting this information about have the opportunity to say, hey, I don't want you to do this anymore. Delete my information. Stop tracking this information about me.
Awesome. Well, I know, Megan, thank you so much. You covered a lot. I'm going to open this for questions. I know we spilled over, guys, but this is probably worth every second if you are looking to protect yourself and protect your business, because you're doing business online, or maybe you're an agency and you're working with end clients. You have to, and I repeat, you have to be on top of your privacy policy, cookie policy, and how the logistics work. So I'm going to put in Megan's information again here, okay, as a promotion. Support Megan, and she's definitely an A+ person to work with. Other than that, I want to open up the floor. Anyone have any questions? I know I have a couple right now here, which I'll cover, but in the meantime, if someone have any questions, drop them in the chat. So Jason asked, have you discussed how Google Analytics may violate GDPR or privacy rights by some of the changes they have recently made? I'm assuming this might be a little bit technical, Megan. What do you think?
So I know that Google Analytics, now I'm not sure exactly which changes or which of their recent changes Jason might be talking about, because I know a lot of their operations are a little bit controversial. Here in the United States, Google Analytics does collect a lot of information about consumers without giving full and transparent disclosures, because in the US, our laws are mostly relevant to consumers that are in California, and Google has the opportunity or ability to sort of segment their market and make sure that there's only disclosures for those individuals. Most businesses just don't have that money. So I believe that Google Analytics sort of skates or flirts the line by spending or investing and segmenting their market, making disclosures to consumers that are in California, and then consumers that are not in California, they don't make those disclosures to, and they don't engage in, I'm going to say they don't engage in the most transparent practices here in the United States. Now, from my understanding, in the recent litigations concerning Google, they are fully in compliance. Well, I can't say they're fully in compliance. However, I don't believe that Google has recently been fined under GDPR violations. From my understanding, they are in compliance with their analytics platform for GDPR purposes, but not fully in the United States because, again, the CCPA only applies to consumers that are in California, and Google has they have stated that they have the technology to segment their market and sort of not collect information from consumers in California without them opting into it. But that's as far as my knowledge goes about Google Analytics and their sort of ongoing litigation and legal battles concerning privacy and privacy regulations. And that could change if the US has a full federal policy. I hope that answered that question.
If I could throw in something as a software guy, they are trying to get around the problem that cookies are being obliterated and stopped, and they are finding other ways to collect the data. Cookies were actually a nice way for companies to collect data because we could all see what was going on because the cookie was on your computer. Now they're going to do it at the server end. It's going to be much more hidden of what they're collecting and how they're collecting it. And I think that's why the worries are around.
So I'm wondering if they're collecting the information at the server end and individuals, I guess I don't know how that information could be volunteered. Then I think it would all be information that they would have to be fully transparent about how they're collecting it. I don't know how you get around that. I know that Google has an impressive legal team that has spent, millions and, hundreds of millions of dollars in the last 4 or 5 years since the GDPR enactment to help stop these privacy regulations from being enacted in other territories. Like in the US, it's just in California, and Google spends a lot of money lobbying against that. So I don't know how you get around it if it's being collected at their server level, because it would be completely unvolunteered. I don't know how you would provide consent at that level. I don't know that.
You still need consent, though. I mean, people need to know what you're collecting and what you're sharing. If that's the essence of every law, they have to obey. I don't think they can get around it any other way.
Again, in the US, they're technically segmenting the market. I don't know how you do that so well. I think it's for their platform. I think it's difficult. Let me say this. There's not a lot of policing here in the US, and I don't think the EU and the UK have the money for a grand policing authority yet. So there's not a lot of policing. Most of these violations, like there was a slide we skipped over that had an example of the H&M case where H&M was collecting information about employees that were actually in their store. And that information came up because someone found out that they were collecting it and using that and tracking employee behavior and also consumer buying behavior in their store. So that's how, someone found out about it. They could have gone on doing that, essentially in perpetuity. So that's really where the problem comes in. There's not enough, support as far as policing comes. It's about when consumer complaints come, that's when these companies are getting fined.
Got it. All right, I'm going to take a few questions. Peter asked, obviously we need cookie policy. Do we need accessibility policy for how people can access? Or I'm assuming if you are serving a specific segment, maybe colorblind and people who have vision issues or hearing issues, I believe that's what you're referring to, Peter, right? Do we need a policy for that?
So under the GDPR and under CCPA, there is a requirement to give individuals, and I don't believe the word is accessibility, but to give individuals that have special accommodations, I think that's the buzzword, special accommodations, the ability to access, either the data controller or a specific designated individual to ask for a different form of communication. So if someone is blind, they should be able to write in and say, or well, maybe they can't write in, I'm not sure how they would do it, but they should be able to get in contact with someone, via relay phone call or something like that to say, hey, can I get a copy of your policies via this mechanism? So that's something I include at the bottom of all of my policies, that if, this could even apply to individuals who just have, that are older, are older in age or need a policy in 14 or 16 point font. Just write us in, tell us what you need, and we'll get that information to you. And of course, you have to balance the burden of doing such. So it depends on what a person's accommodation is. So I would just say, try to work with them, just have a mechanism for a consumer to contact you and request that information.
Right. Jason added, if I have Google Analytics on my site, or some people are just turning it off by default, worrying about all this stuff. I think the best way is my recommendation. If you created a cookie policy or cookie widget where people have to see exactly what you're collecting and the details of what Google Analytics is collecting, and they have to say yes, or it's turned off by default, I think that's the first layer of protection. And you definitely have to go back to their site and follow their resources for this. There's a lot more to it with this short period of time. That's what we did. We have Google Analytics, we have Google Tag Manager, we have some endpoints. When people disable Google Analytics by using the cookie widget, we turn off Google Analytics. So leave it at the hand of the person browsing, and the default should be it's off. And that's the best way to move forward, I think.
Yeah, and to Jason's point, yes, that's absolutely what Google does. They push the burden of compliance and responsibility and liability on the site owner. That's exactly what Google does.
Cool. I have a question. I think I don't think I missed any. George, if you see any in the chat on Facebook, please let me know. But that's a question everybody asks. If my servers are located in the United States and I'm doing business with companies in EU and clients are in the EU, and I have all my contractual clauses, privacy policy buttoned up, am I still under the legal obligation of a GDPR? Am I still GDPR compliant?
Yes. If you're marketing or collecting information for consumers that are in the EU, even if you're not located in the EU, you are subject to the mandates of GDPR. And it's okay. A lot of companies are, they think that if you're not located in the EU, that you can't collect information on EU data subjects, or they can't do business with you. That's absolutely not true. There's a certain list of countries that are permissible to share data with, outside of the EU without any additional accommodations or anything like that. The United States is not one of them because we don't have a federal sort of privacy law. There's a certain list of countries, and I think I list them in one of our slides that we might have bypassed. But the United States isn't one of them, but you do need to be GDPR compliant. You can absolutely do business with companies that are in the EU. You can absolutely collect information from data subjects, but you have to be GDPR compliant. So you're responsible for knowing what the GDPR regulations are and for being compliant with them.
Well, thanks for answering, Megan. I will probably have to conclude the call. We're at 6:30. Thank you for staying an extra 30 minutes, Megan, and everybody else. So John, thank you for helping us out on the Zoom with the technical stuff and answering questions. That was great. I would love to connect with you otherwise. But again, thank you everyone for joining in. Special thanks to Megan Thomas. Her information are on here. Support Megan if you're looking for an attorney around privacy and buying up your privacy compliance, cookie policy, and so on. We've worked with her, and I can vouch for her good work. Other than that, thank you, everyone. And I look forward to seeing you next month on the second Wednesday for another great topic around marketing. So from until then, you'll get summary of this recording. You'll also get the slides, and you'll get Megan's information in an email so you can contact her directly. So thanks everyone for joining. Megan, thank you so much.
Thank you, everyone. Bye.
Bye-bye.